Minnesota Real Estate Exam Full Practice Test. Question 1. During negotiations in Woodbury, Drew Peterson changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A. It is a counteroffer that rejects the original offer and proposes new terms. Option B. It is an acceptance because some terms stayed the same. Option C. It creates a lease instead of a purchase contract. Option D. It keeps the original offer open forever. The correct answer is option A. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 2. A broker refuses to show listings unless a buyer also uses the broker's mortgage affiliate. What antitrust concept could be implicated for Sawyer and Brainerd involving a newly built townhouse priced at $232,500? Option A. Accretion. Option B. Tie-in arrangement. Option C. Estoppel. Option D. Substitution principle. The correct answer is option B. Tie-in arrangement. A tie-in arrangement conditions one service on the purchase of another service and can raise antitrust concerns. Accretion, estoppel, and substitution are property or valuation concepts. Consumers should not be unlawfully forced into affiliated services. Question 3. If one broker represents both Jordan Garcia and Quinn Wilson in a residential transaction, what must occur before the broker acts as a dual agent? Option A. Only the seller must consent because the seller listed the property. Option B. The broker may proceed without consent if the commission is reduced. Option C. All parties must give informed consent to the dual agency relationship. Option D. Consent is unnecessary if two different salespersons are involved. The correct answer is option C. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 4. Before Avery schedules the salesperson examination after studying in Egan, which pre-license course must already be completed? Option A. Course 2 only. Option B. Course 3 only. Option C. The annual continuing education module. Option D. Course I. The correct answer is option D. Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 5. A property manager collects rent for an owner in Bloomington. How should those funds generally be treated before proper disbursement for Jordan in Bloomington involving a farm parcel priced at $340,500? Option A. As trust funds handled according to the broker's trust account obligations. Option B. As the manager's personal operating funds. Option C. As sales tax collected for the state. Option D. As title insurance premiums. The correct answer is option A. As trust funds handled according to the broker's trust account obligations. Rent collected for an owner is money held for another and must be handled under trust accounting duties. It is not the manager's personal money, a sales tax fund, or a title insurance premium. Property management requires careful separation of client funds. Question 6. If Jordan fails to complete required continuing education by the renewal deadline, what license consequence can occur for Jordan in Bloomington involving a condominium unit priced at $284,000? Option A. The license automatically converts to a broker license. Option B. The license can become inactive. Option C. The license becomes a deed restriction. Option D. The license renews for free without further action. The correct answer is option B. The license can become inactive. Failure to complete continuing education before the deadline can cause a Minnesota real estate license to become inactive. It does not upgrade the license, affect title to property, or waive renewal obligations. Continuing education is a condition of maintaining active status. Question 7. Which lease gives a tenant possession for a fixed term that ends automatically on the stated expiration date for Morgan in Moorhead involving a duplex priced at $397,500? Option A, tenancy at sufferance. Option B, fee simple defeasible. Option C, the estate for years. Option D, easement appurtenant. The correct answer is option C, estate for years. An estate for years is a leasehold for a definite period and ends at the stated expiration. Tenancy at sufferance is holdover possession after lawful possession ends. Fee simple defeasible and easement appurtenant are not ordinary fixed-term leasehold estates. Question 8. A Woodbury buyer's loan has small monthly payments but one large final payment. What is that final payment called for Casey in Woodbury involving a mixed-use property priced at $438,500? Option A, proration credit. Option B, replacement reserve. Option C, equity dividend. Option D, a balloon payment. The correct answer is option D, balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing, a replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 9. Which ownership estate gives Jordan Rivera the greatest bundle of rights with no stated end date or condition? Option A, fee simple absolute. Option B, estate at sufferance. Option C, life estate. Option D, license. The correct answer is option A, fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 10. A contract substitutes a new party and releases the original party from liability. Which term best describes that change for Kendall in St. Cloud involving a rental house priced at $248,500? Option A, assignment only. Option B, novation. Option C, accretion. Option D, hypothecation. The correct answer is option B, novation. Novation substitutes a new obligation or party and releases the original party when all required parties agree. Assignment transfers rights but does not necessarily release the assignor. Accretion and hypothecation involve land buildup and pledging property as security. Question 11. During a first substantive contact with a residential consumer in Bloomington, what disclosure should the licensee provide for Jordan in Bloomington involving a condominium unit priced at $219,500? Option A, a final closing disclosure showing loan terms. Option B, a county tax statement for the current year. Option C, an agency disclosure form explaining available agency and facilitator relationships. Option D, a deed prepared for recording. The correct answer is option C, an agency disclosure form explaining available agency and facilitator relationships. Minnesota requires an agency disclosure form at the first substantive contact in residential transactions covered by the statute. The form explains representation choices and facilitator status before the consumer decides whether to enter a representation contract. Closing disclosures, tax statements, and deeds serve different functions later in the transaction. Question 12. A property owner dies with no will and no heirs. What government power may transfer the property to the state for Blair in Minneapolis involving a lake cabin priced at $310,500? Option A, eminent domain. Option B, literal rights. Option C, subordination. Option D, escheat. The correct answer is option D, escheat. Escheat transfers property to the state when an owner dies without a will and without heirs. Eminent domain involves compensated taking, literal rights involve water, and subordination changes lien priority. The absence of heirs is the clue. Question 13. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Reese in Stillwater involving a vacant lot priced at $201,500? Option A. Reasonable accommodation. Option B. Adverse possession. Option C. Yield spread premium. Option D. Defeasance clause. The correct answer is option A. Reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 14. A pooled interest-bearing trust account earns interest on client funds, unless otherwise agreed, where is the interest generally paid under Minnesota rules for Reese in Stillwater involving a vacant lot priced at $307,500? Option A. To the salesperson as a bonus. Option B. To the Minnesota Housing Finance Agency for the Housing Trust Fund account. Option C. To the listing client automatically. Option D. To the county assessor's operating budget. The correct answer is option B. To the Minnesota Housing Finance Agency for the Housing Trust Fund account. Minnesota rules direct interest from pooled trust accounts, less reasonable costs, to the Minnesota Housing Finance Agency for the Housing Trust Fund account unless the parties specify otherwise. The salesperson, listing client, and county assessor are not the default recipients. Trust account interest is regulated separately from commission. Question 15. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for Quinn in Edina involving a mixed-use property priced at $383,500? Option A. Keep the entire deposit automatically as a cleaning fee. Option B. Apply the deposit to the broker's commission. Option C. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Option D. Record the deposit with the county as a deed restriction. The correct answer is option C. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 16. A buyer transfers contract rights to another buyer but remains liable unless released. What is this called for Quinn in Edina involving a lake cabin priced at $257,500? Option A. Novation with automatic release. Option B. This cheat. Option C. Ad valorem taxation. Option D. Assignment. The correct answer is option D. Assignment. Assignment transfers contractual rights to another party, but the assignor can remain liable unless a release or novation occurs. Is cheat and ad valorem taxation are unrelated. The distinction between assignment and novation is commonly tested. Question 17. A salesperson tells owners in Stillwater to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe? Option A. Blockbusting. Option B. Reconciliation. Option C. Hypothecation. Option D. Assemblage. The correct answer is option A. Blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step, hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 18. A zoning ordinance limits building height in St. Cloud. What government power is most directly involved for Kendall in St. Cloud involving a rental house priced at $452,000? Option A. Eminent domain. Option B. Police power. Option C. This cheat. Option D. Taxation only. The correct answer is option B. Police power. Police power allows government to regulate property use for health, safety, morals, and general welfare. Eminent domain is taking for public use, escheat handles ownerless property, and taxation raises revenue. Zoning is a classic police power regulation. Question 19. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for Quinn and Edina involving a mixed-use property priced at $313,000? Option A. To change the sales price after acceptance. Option B. To avoid recording the deed. Option C. To allocate income or expenses to the party who owned the property during the relevant time period. Option D. To eliminate the need for title insurance. The correct answer is option C. To allocate income or expenses to the party who owned the property during the relevant time period. Priorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 20. Under Chapter 82 Standards, what must a broker do to properly supervise salespersons at a Stillwater office for Reese and Stillwater involving a farm parcel priced at $474,000? Option A. Let each salesperson approve their own contracts without broker review. Option B. Delegate all trust records to buyers and sellers. Option C. Supervise only advertising and ignore purchase agreements. Option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. The correct answer is option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 21. In a dual agency situation in Blaine, why must the licensee avoid advocating exclusively for one party for Cameron and Blaine involving a townhome priced at $342,500? Option A. The broker owes duties to both buyer and seller within the limits of dual agency. Option B. The broker becomes a government mediator. Option C. The buyer automatically becomes the broker's only client. Option D. The seller's broker relationship disappears at acceptance. The correct answer is option A. The broker owes duties to both buyer and seller within the limits of dual agency. Dual agency means the broker owes duties to both sides and must work within those limits. The broker is not converted into a government mediator, and neither party becomes the only client. Acceptance of an offer does not eliminate the agency relationship or the disclosure limits. Question 22. A $316,000 sale carries a 7% commission. What is the total commission before any split? Option A, $63,200. Option B, $22,120. Option C, $3,792. Option D, $4,835. The correct answer is option B, $22,120. Total commission is found by multiplying the sale price by the commission rate. Down payment, discount points, and property tax calculations use different bases. The phrase before any split means the full brokerage commission is calculated first. Question 23. Which fiduciary duty requires a broker to keep client money and property properly accounted for Avery in Winona involving a townhome priced at $277,500? Option A, assemblage. Option B, accretion. Option C, accounting. Option D, divulsion. The correct answer is option C, accounting. Accounting requires a broker to account for money and property received on behalf of a client. Assemblage, accretion, and avulsion are property or land concepts, not fiduciary duties. The key clue is handling client property and funds. Question 24. A rental property produces $52,000 in net operating income and investors require a 6% capitalization rate. What value is indicated by the income approach? Option A, $165,000. Option B, $332,625. Option C, $7,200. Option D, $866,667. The correct answer is option D, $866,667. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 25. A licensee in Egan drafts a complex legal clause for Skylar Nolan instead of recommending legal counsel. What risk is created? Option A, unauthorized practice of law. Option B, constructive eviction. Option C, functional obsolescence. Option D, inverse condemnation. The correct answer is option A, unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 26. A landlord in Duluth deducts from a security deposit for unpaid rent and damage beyond ordinary wear and tear. What makes those deductions more defensible for Drew in Duluth involving a vacant lot priced at $323,000? Option A. They are based only on the landlord's dislike of the tenant. Option B. They are tied to permitted reasons and supported by a written explanation. Option C. They include normal fading of paint from ordinary use. Option D. They are taken without notice because deposits are always non-refundable. The correct answer is option B. They are tied to permitted reasons and supported by a written explanation. Minnesota security deposit deductions are generally tied to unpaid obligations or damage beyond ordinary wear and tear, with a written explanation when money is withheld. Personal dislike, normal wear, and treating every deposit as non-refundable are not defensible bases. Documentation is essential in landlord-tenant accounting. Question 27. A buyer receives a qualified third-party inspection report, but the licensee knows a fact that contradicts it. What must the licensee do for Avery in Winona involving a townhome priced at $214,000? Option A, stay silent because the report always controls. Option B, destroy the report and order a new one. Option C, disclose known facts that contradict the report. Option D, tell only the inspector after closing. The correct answer is option C, disclose known facts that contradict the report. A licensee may rely on a qualified third-party report unless the licensee knows facts that contradict it. Known contradictions must be disclosed to the parties. Silence, destruction of the report, or delayed notice would undermine the disclosure duty. Question 28. Two investors own a Brainerd duplex with unequal shares and no survivorship language. Which ownership form is most likely for Sawyer and Brainerd involving a townhome priced at $355,000? Option A, tenancy by the entirety. Option B, severalty. Option C, life tenancy only. Option D, tenancy in common. The correct answer is option D, tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life. Tenancy by the entirety is a special marital form not described by unequal investor shares. Question 29. A lender draws a line around a Washington neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits for Morgan in Moorhead involving a rental house priced at $233,500? Option A, redlining. Option B, plottage. Option C, accretion. Option D, estoppel. The correct answer is option A, redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 30. A licensee directs families with children only toward one area of Woodbury. What fair housing problem does that conduct create for Casey in Woodbury involving a mixed-use property priced at $205,000? Option A, amortization. Option B, steering. Option C, subordination. Option D, novation. The correct answer is option B, steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 31. If a seller rejects Jordan Wilson's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A, only after the seller signs a different purchase agreement. Option B, at the end of the listing period. Option C, no later than the next business day after rejection. Option D, after the broker deducts marketing expenses. The correct answer is option C, no later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 32. A tenant remains in possession after a lease expires without the landlord's consent. What is the tenant's status for Sawyer in Brainerd involving a townhome priced at $334,500? Option A, remainderman. Option B, joint tenant. Option C, dominant tenant. Option D, tenant at sufferance. The correct answer is option D, tenant at sufferance. A tenant at sufferance is a holdover who originally had lawful possession but stays without consent after the right ends. A remainderman holds a future interest, a joint tenant is a co-owner, and dominant tenant is not the standard term. The holdover fact controls. Question 33. If Drew Lee tells the licensee that the seller will not perform under the signed purchase agreement, what must the licensee do? Option A, immediately disclose the stated intent not to perform to the other party or parties. Option B, keep the information confidential until the closing date. Option C, cancel the agreement without telling the buyer. Option D, disclose only if the seller misses a loan contingency. The correct answer is option A, immediately disclose the stated intent not to perform to the other party or parties. A licensee put on notice that a party will not perform according to the transaction agreement must disclose that intent to the other party or parties. Keeping the information secret would mislead the other side. The rule is different from a party's inability to satisfy a contingency. Question 34. For Finley Peterson's first real estate job in Bemidji, who submits the Minnesota salesperson license application after the applicant becomes associated with a broker? Option A, the applicant directly through a personal account only. Option B, the licensed real estate broker with whom the applicant is associated. Option C, the listing client from the applicant's first transaction. Option D, the county recorder in the county where the applicant lives. The correct answer is option B, the licensed real estate broker with whom the applicant is associated. A Minnesota salesperson must be associated with a licensed broker, and the broker submits the license application. The applicant alone does not file the salesperson application, clients have no filing role, and county recorders do not issue salesperson licenses. Broker sponsorship is central to salesperson licensure. Question 35. A buyer deposits earnest money with a broker in the form of a negotiable note rather than cash. What extra care is needed for Parker in Maple Grove involving a duplex priced at $347,500? Option A, the broker may throw it away because it is not cash. Option B, it can be placed in the broker's personal safe without records. Option C, the non-depositable item must be handled through authorized escrow with written authority and proper records. Option D, it automatically becomes commission income. The correct answer is option C. The non-depositable item must be handled through authorized escrow with written authority and proper records. Non-depositable items received as earnest money require careful escrow handling, written authority when the broker holds them, and proper records. They are not discarded, hidden as personal property, or treated as commission income. The rule protects all parties' interests in non-cash deposits. Question 36. A broker tells competing firms to keep commissions at the same percentage in St. Cloud. What legal risk is most obvious? Option A, accretion. Option B, constructive eviction. Option C, functional obsolescence. Option D, price fixing under antitrust law. The correct answer is option D, price fixing under antitrust law. Competitors agreeing on commission rates can be price fixing, an antitrust violation. Accretion, constructive eviction, and functional obsolescence involve land change, landlord-tenant issues, and valuation. Commissions must be independently negotiated, not fixed by competitors. Question 37. In appraisal, what does highest and best use require for Jordan in Bloomington involving a farm parcel priced at $372,500? Option A. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Option B. The use that produces the highest commission. Option C. The use preferred by the current tenant only. Option D. The use with the lowest property tax bill. The correct answer is option A. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 38. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Hayden in Northfield involving a duplex priced at $306,000? Option A, accretion. Option B, amortization. Option C, subordination. Option D, cheat. The correct answer is option B, amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup, subordination changes lien priority, and cheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 39. Before advertising Riley Davis's farm parcel to the general public, what must a Minnesota licensee obtain? Option A. An oral promise that the owner may list later. Option B. A buyer's pre-approval letter. Option C. A signed listing agreement or other signed written authorization from the owner or authorized person. Option D. A tax parcel map from the county. The correct answer is option C. A signed listing agreement or other signed written authorization from the owner or authorized person. A licensee must have a signed listing agreement or other signed written authorization before advertising real property for sale or lease to the general public. Oral permission is not enough for this requirement. Buyer pre-approval and tax maps may be useful, but they do not authorize public advertising. Question 40. Under federal fair housing law, which group is a protected class in the sale or rental of housing for Emerson and Red Wing involving a lake cabin priced at $228,000? Option A, credit score above 700. Option B, preference for lakefront homes. Option C, employment in real estate sales. Option D, familial status. The correct answer is option D, familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 41. While interviewing with two firms in Woodbury, Quinn asks how many Minnesota brokers may supervise the salesperson during the same period. Option A. 1 actively licensed broker. Option B. 2 brokers if both brokers consent. Option C. Any number of brokers if the salesperson discloses the arrangement. Option D. 1 broker for residential sales and a separate broker for leases. The correct answer is option A, 1 actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of one broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 42. A garage built on Blair Peterson's land extends 2 feet over the boundary onto a neighbor's parcel. What issue is created? Option A, hypothecation. Option B, encroachment. Option C is subrogation. Option D, reconciliation. The correct answer is option B, encroachment. An encroachment occurs when an improvement physically intrudes onto another parcel. Hypothecation pledges property for debt, subrogation substitutes one party's claim, and reconciliation is an appraisal conclusion step. The garage crossing the boundary is the key fact. Question 43. A borrower signs a promissory note and mortgage to finance a St. Paul home. What does the note do for Skylar in St. Paul involving a fourplex priced at $321,000? Option A, transfers title to the lender at closing. Option B, sets the zoning classification. Option C, creates the borrower's personal promise to repay the debt. Option D, records the deed tax payment. The correct answer is option C, creates the borrower's personal promise to repay the debt. The promissory note is the borrower's promise to repay according to the loan terms. The mortgage secures that promise with a lien on the property. Zoning, title transfer, and deed tax are separate matters. Question 44. Why might Finley Okafor use a quitclaim deed to clear a possible title issue? Option A, it guarantees the property is free of every lien. Option B, it creates a new mortgage automatically. Option C, it replaces the need for delivery and acceptance. Option D, it transfers whatever interest the grantor may have without making title warranties. The correct answer is option D, it transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 45. Which deed gives Blair Rivera the broadest set of title warranties from the grantor? Option A, general warranty deed. Option B, quitclaim deed. Option C, bargain and sale deed with no covenants. Option D, tax certificate only. The correct answer is option A, general warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 46. A broker closes an existing trust account without notice. Why is that a problem under Minnesota trust account rules for Kendall in St. Cloud involving a duplex priced at $442,000? Option A, trust accounts may never be changed under any circumstances. Option B, a broker or closing agent must give written notice to the commissioner before closing an existing trust account. Option C, only buyers can close brokerage trust accounts. Option D, trust accounts are optional for earnest money. The correct answer is option B. A broker or closing agent must give written notice to the commissioner before closing an existing trust account. Minnesota rules require notice of trust account status changes and written notice before closing an existing account. This does not mean accounts can never change, but they must be properly reported. Buyers do not control brokerage trust accounts, and trust accounts are not optional when trust funds must be held. Question 47. Which event usually allows trust funds in a Minnesota real estate transaction to be disbursed for Drew in Duluth involving a farm parcel priced at $215,500? Option A, a verbal request from one salesperson. Option B, a social media announcement that the deal is done. Option C, closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Option D, the buyers hope to renegotiate after closing. The correct answer is option C, closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Trust funds may be disbursed only under recognized authority such as closing, written agreement, applicable statutory affidavit, or court order. A verbal request or social media post does not provide the necessary authority. A buyer's later wish to renegotiate is not a trust fund disbursement event. Question 48. What is the main purpose of an owner's title insurance policy for Emerson Patel? Option A. To insure the roof against storm damage. Option B. To guarantee future market appreciation. Option C. To replace the need for a purchase agreement. Option D. To protect against covered title defects that existed before the policy date. The correct answer is option D. To protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 49. A licensee exaggerates by saying a backyard view is the best sunset in Minnesota. How is that usually classified for Harper in Rochester involving a newly built townhouse priced at $217,500? Option A. Puffing if it is clearly opinion rather than a factual claim. Option B. A guaranteed appraisal. Option C. A material title defect. Option D. A deed restriction. The correct answer is option A. Puffing if it is clearly opinion rather than a factual claim. Puffing is an opinion or sales statement that a reasonable person would not treat as a factual guarantee. It differs from misrepresenting a known defect or title issue. The sunset statement is subjective unless tied to a specific false fact. Question 50. If annual property taxes of $5,600 are prorated to the seller for 135 days on a 365-day basis, approximately what amount is charged to the seller? Option A. $18,300. Option B. $2,071. Option C. $2,745. Option D. $1,258. The correct answer is option B. $2,071. Tax proration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Proration allocates an annual expense fairly between buyer and seller at closing. Question 51. In Brainerd, a new applicant asks which combination best describes the salesperson licensing path in Minnesota for Sawyer and Brainerd involving a small retail building priced at $352,500. Option A. Be at least 21, complete only course I, and work independently after passing the exam. Option B. Complete continuing education before any pre-license education and apply directly without a broker. Option C. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Option D. Pass only the national exam and begin practicing while the application is pending. The correct answer is option C. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 52. At Granite Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers for Kendall and St. Cloud involving a fourplex priced at $321,000. Option A. MLS Grid. Option B. Torrens Online. Option C. HUD Exchange. Option D. Pulse. The correct answer is option D. Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 53. Under Minnesota law, which statute is the primary source for real estate broker and salesperson regulation for Avery in Winona involving a newly built townhouse priced at $317,000? Option A, Minnesota Statutes Chapter 82. Option B, Minnesota Statutes Chapter 287 only. Option C, the Federal Internal Revenue Code only. Option D, a local MLS policy manual only. The correct answer is option A, Minnesota Statutes Chapter 82. Chapter 82 governs real estate brokers and salespersons in Minnesota. Chapter 287 covers deed tax and mortgage registry tax topics, and federal tax law or MLS policies do not replace state licensing law. Exam questions often test which authority controls licensing conduct. Question 54. Before negotiating a purchase involving a licensee's sibling as a principal, what should the licensee do for Hayden in Northfield involving a fourplex priced at $263,000? Option A, say nothing because relatives are not licensees. Option B, disclose the relationship in writing before negotiating or consummating the transaction. Option C, disclose only after the commission is paid. Option D, ask the lender to disclose it instead. The correct answer is option B, disclose the relationship in writing before negotiating or consummating the transaction. Minnesota requires written disclosure when a principal is a licensee's relative or business associate. Waiting until after commission payment is too late, and the duty is not shifted to the lender. The rule protects parties from undisclosed conflicts of interest. Question 55. Which Minnesota tax is generally associated with recording a deed that conveys real property for Riley in Bemidji involving a farm parcel priced at $351,500? Option A, mortgage registry tax only. Option B, utility franchise fee. Option C, state deed tax. Option D, federal gift tax return fee. The correct answer is option C, state deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 56. If an override clause appears in Riley Rivera's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective? Option A, a new deed. Option B, a county tax appeal. Option C, a mortgage payoff statement. Option D, a protective list. The correct answer is option D, a protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 57. A residential buyer has not signed a representation contract. How should the licensee describe the buyer's status after agency disclosure for Finley in Mankato involving a single-family home priced at $398,500? Option A. The buyer is a customer unless and until a written representation contract is signed. Option B. The buyer is automatically a client forever. Option C. The buyer becomes the broker's employee. Option D. The buyer receives ownership rights in the brokerage. The correct answer is option A. The buyer is a customer unless and until a written representation contract is signed. Minnesota agency disclosure explains that a consumer is not represented until a written representation contract is signed. Customer status is different from client representation. Employment and ownership rights are not created by receiving agency disclosure. Question 58. A city takes private land for a public road after paying just compensation. What power is being exercised for Finley in Mankato involving a single-family home priced at $210,000? Option A is cheat. Option B, eminent domain. Option C, adverse possession. Option D, police power only. The correct answer is option B, eminent domain. Eminent domain is the government's power to take private property for public use with just compensation. Escheat transfers property to the state when no heirs exist, and adverse possession is private acquisition through possession. Police power regulates use but does not by itself describe a compensated taking. Question 59. Under the Minnesota Human Rights Act, which protected basis expands beyond the traditional federal fair housing list for Emerson and Red Wing involving a single-family home priced at $233,500? Option A, preference for a short commute. Option B, owning 2 vehicles. Option C, status with regard to public assistance. Option D, having a fixed-rate mortgage. The correct answer is option C, status with regard to public assistance. Minnesota housing and real property discrimination law includes status with regard to public assistance among protected bases. Commute preference, vehicle ownership, and mortgage type are not protected classes. State law can add protections beyond the federal baseline. Question 60. A Woodbury parcel contains 11 acres. How many square feet are in the parcel? Option A, $37,800. Option B, $262,125. Option C, $7,305. Option D, $479,160. The correct answer is option D, $479,160. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 61. A deed expressly creates survivorship between co-owners of a duplex. Which ownership feature is being emphasized for Morgan in Moorhead involving a duplex priced at $203,000? Option A, right of survivorship in joint tenancy. Option B, no right to possess the property. Option C, a tenant's trade fixture right. Option D, a mortgagee's foreclosure priority. The correct answer is option A, right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 62. A buyer asks whether a nursing home in the neighborhood must be disclosed as a material fact. How does Minnesota treat the issue for Casey in Woodbury involving a lake cabin priced at $406,500? Option A, it is always a material defect in the property. Option B, the location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Option C, it requires a separate appraisal license. Option D, it makes the deed void. The correct answer is option B. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Minnesota law excludes certain neighborhood-related facilities, including nursing homes, from material fact treatment merely because they are nearby. This does not remove duties to disclose physical defects or known material facts. Appraisal licensing and deed validity are unrelated. Question 63. A broker learns that a foundation defect could significantly affect Sawyer Davis's use of a fourplex in St. Paul. What should the broker do? Option A, stay silent because the defect might reduce the seller's price. Option B, disclose only after closing if the buyer complains. Option C, disclose the material fact to the prospective purchaser. Option D, treat the defect as confidential even if it affects use and enjoyment. The correct answer is option C, disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 64. A Cedar Realty branch office wants licensees to access current Minnesota statutes and rules electronically. Is electronic access acceptable for Kendall in St. Cloud involving a duplex priced at $286,000? Option A, No, only a paper binder signed by every buyer is allowed. Option B. Yes, but only if clients pay a records fee. Option C. No, statutes are never required in real estate offices. Option D. Yes, access to required statutes and rules may be made available electronically. The correct answer is option D. Yes, access to required statutes and rules may be made available electronically. Minnesota standards allow access to required statutes and rules through an electronic agent. A paper-only rule, client fee requirement, or no access approach misstates the standard. The point is that licensees must have current legal resources available. Question 65. During a Brainerd license renewal review, which continuing education schedule best matches Minnesota salesperson requirements for Sawyer and Brainerd involving a townhome priced at $372,500? Option A, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Option B, 10 hours every 4 years with no annual deadline. Option C, 30 hours only during the first licensing year. Option D, only the required module with no other continuing education. The correct answer is option A, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 66. A listing agreement for a Minneapolis seller is missing a definite end date. Why is that a licensing problem? Option A. Listing agreements are valid only if they renew forever. Option B. Minnesota listing agreements must include a definite expiration date. Option C. Expiration dates are allowed only in commercial leases. Option D. The county recorder assigns the expiration date after closing. The correct answer is option B. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 67. After passing the examination, Parker wants to submit a Minnesota salesperson license application immediately. Which education requirement still must be met before applying for Parker in Maple Grove involving a duplex priced at $329,500? Option A. Only course I is ever required for the license. Option B. A broker's 30-hour course must replace course 3. Option C. Courses 2 and 3 must be successfully completed if they have not already been completed. Option D. No additional education is needed once the exam is passed. The correct answer is option C. Courses 2 and 3 must be successfully completed if they have not already been completed. Course I opens exam eligibility, but courses 2 and 3 must be completed before the salesperson license application. Passing the exam does not erase the remaining pre-license education requirement. The other options either omit required courses or invent a broker-only replacement course. Question 68. A Duluth salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper for Drew in Duluth involving a vacant lot priced at $333,000? Option A. Personal funds must always be kept in the listing broker's trust account. Option B. Salespersons may use trust accounts as savings accounts with broker consent. Option C. Commingling is allowed when the amount is less than 1 month's rent. Option D. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. The correct answer is option D. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 69. If a Bemidji property sells for $426,500 and the buyer obtains an 85% loan, what is the buyer's down payment? Option A, $63,975. Option B, $362,525. Option C, $27,722. Option D, $4,190. The correct answer is option A, $63,975. The down payment is the sale price minus the loan amount. The loan amount is the financed portion, the commission is a brokerage compensation calculation, and the tax proration allocates property taxes. Separating buyer equity from loan proceeds is a core exam math skill. Question 70. A Minnesota salesperson renewal fee includes a contribution to which fund for Quinn and Edina involving a mixed-use property priced at $295,000? Option A, Federal Flood Insurance Reserve. Option B, Real Estate Education, Research and Recovery Fund. Option C, County Recording Technology Fund only. Option D, Private MLS Scholarship Account. The correct answer is option B, Real Estate Education, Research and Recovery Fund. Minnesota salesperson license fees include an amount for the Real Estate Education, Research and Recovery Fund. Flood insurance reserves, county recording funds, and private MLS accounts are unrelated. The fund is part of the state licensing fee structure. Question 71. Which fiduciary duty requires a broker to follow a client's lawful directions for Blair in Minneapolis involving a lake cabin priced at $396,000? Option A is cheat. Option B, novation. Option C, obedience. Option D, subordination. The correct answer is option C, obedience. Obedience requires following lawful client instructions. It does not require obeying illegal instructions or ignoring disclosure duties. Is cheat, novation, and subordination are unrelated legal concepts. Question 72. Why would an appraiser rely heavily on the cost approach for a newly built mixed-use property in Minneapolis for Blair in Minneapolis involving a mixed-use property priced at $332,500? Option A. It ignores land value completely. Option B. It is the only legal method for all residential property. Option C. It values the property only by monthly rent. Option D. Replacement cost and depreciation can be estimated more reliably for new improvements. The correct answer is option D. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 73. A licensee in Mankato wants to know which required continuing education topics must be included in the renewal cycle along with the general module for Finley in Mankato involving a single-family home priced at $361,000. Option A, Agency Law and Fair Housing. Option B, only appraisal theory and mortgage underwriting. Option C, only property insurance and income tax preparation. Option D, only construction codes and zoning administration. The correct answer is option A, Agency Law and Fair Housing. Minnesota renewal requirements include agency representation and disclosure training and fair housing training as part of the required education mix. Appraisal, insurance, tax, construction, and zoning topics may be useful, but they do not replace those mandated topics. The rule is designed to keep licensees current on representation and anti-discrimination duties. Question 74. Why should a purchase agreement for a mixed-use property in Edina be in writing and signed by the party to be charged? Option A. All oral contracts are criminal offenses. Option B. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option C. Only lenders may sign real estate contracts. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option B. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 75. A deed gives Morgan possession for life, then ownership passes to Harper Kahn. What interest does Harper Kahn hold before Morgan's death? Option A, leasehold estate. Option B, easement in gross. Option C, remainder interest. Option D, mortgage lien. The correct answer is option C, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 76. A social media ad for a lake cabin in Minneapolis uses a team name. What must the advertisement clearly and conspicuously display for Blair in Minneapolis involving a lake cabin priced at $331,500? Option A. Only the salesperson's nickname. Option B. Only the property street address. Option C. Only the team logo without the brokerage. Option D. The real estate brokerage name. The correct answer is option D, the real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 77. A salesperson discovers an error in an advertisement after publication. What is the most professional next step for Quinn in Edina involving a lake cabin priced at $267,500? Option A. Promptly correct the advertisement and notify the broker according to office procedures. Option B. Ignore it because errors in ads never matter. Option C. Blame the buyer publicly. Option D. Delete all transaction records. The correct answer is option A. Promptly correct the advertisement and notify the broker according to office procedures. Advertising must be accurate and compliant, so prompt correction and broker notification are appropriate. Ignoring errors, blaming clients, or deleting records creates greater compliance risk. Professional practice requires correction and documentation. Question 78. A utility company has the right to run power lines across a Egan parcel. Which property right is usually involved? Option A, estate for years. Option B, easement in gross. Option C, divulsion. Option D, a remainder interest. The correct answer is option B, easement in gross. A utility easement often benefits a company rather than a neighboring parcel, making it an easement in gross. An estate for years is a leasehold, a avulsion is sudden land change, and a remainder follows a life estate. The utilities right is a non-possessory use right. Question 79. A facilitator working with Jordan in Bloomington performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A, loyalty to the seller only. Option B, obedience to the buyer's investment goals. Option C, confidentiality. Option D, advocacy for the party paying the commission. The correct answer is option C, confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 80. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Taylor and Egan involving a townhome priced at $453,500? Option A, cost approach only. Option B, income approach only. Option C, front foot method only. Option D, sales comparison approach. The correct answer is option D, Sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 81. In a gross lease for a St. Cloud office, which cost structure is most typical for Kendall and St. Cloud involving a fourplex priced at $292,000? Option A. The landlord pays most property operating expenses from the rent received. Option B. The tenant pays all property taxes, insurance, and maintenance separately. Option C. The tenant receives title at the end of the lease. Option D. The rent is based only on retail sales volume. The correct answer is option A. The landlord pays most property operating expenses from the rent received. In a gross lease, the landlord typically pays most operating expenses and receives rent as a gross amount. Net leases shift more expenses to the tenant, and percentage leases tie rent partly to sales. A lease does not transfer title merely because it is gross. Question 82. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Reese in Stillwater involving a farm parcel priced at $195,500? Option A. The salesperson may continue independently for 90 days. Option B. The salesperson's license becomes inactive until proper association is restored. Option C. The salesperson automatically becomes a limited broker. Option D. The salesperson may transfer clients without broker supervision. The correct answer is option B. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 83. A buyer representation agreement in Stillwater is best described as what type of document for Reese in Stillwater involving a vacant lot priced at $414,000? Option A. A deed transferring title to the buyer. Option B. A loan commitment from the lender. Option C. A written contract that creates agency representation for the buyer. Option D. A property tax statement from the county. The correct answer is option C. A written contract that creates agency representation for the buyer. A buyer representation agreement is the written contract that creates buyer agency. It does not transfer title, approve financing, or state county taxes. Representation contracts define the broker-client relationship and compensation terms. Question 84. A zoning board permits a property use that otherwise violates strict zoning because of unique hardship. What relief is typically granted for Parker in Maple Grove involving a fourplex priced at $442,500? Option A. Certificate of title. Option B. Quitclaim covenant. Option C. Mortgage assumption. Option D. Variance. The correct answer is option D. Variance. A variance provides relief from strict zoning requirements when legal standards are met, often involving unique hardship. Certificates of title, quitclaim deeds, and mortgage assumptions do not authorize zoning deviations. Land use approval is the issue. Question 85. An easement benefits a neighboring parcel by allowing driveway access across Skylar Anderson's land. What type of easement is most likely? Option A. Easement appurtenant. Option B. Personal license only. Option C. Trade fixture. Option D. A mechanic's lien. The correct answer is option A. Easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 86. A seller accepts an offer only after the buyer receives financing approval. What type of clause is most likely involved for Harper in Rochester involving a townhome priced at $410,000? Option A. Habendum clause. Option B. Financing contingency. Option C, subordination clause. Option D, acceleration clause only. The correct answer is option B, financing contingency. A financing contingency makes performance depend on loan approval or financing terms. A habendum clause appears in deeds, subordination changes lien priority, and acceleration makes a debt due after default. The condition involves financing approval. Question 87. A lender offers Blair Wilson a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A, package mortgage only. Option B, open-end listing. Option C, adjustable rate mortgage. Option D, a graduated lease. The correct answer is option C, adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 88. Gradual soil buildup along a stream increases a parcel's size. What term best fits for Parker in Maple Grove involving a fourplex priced at $372,000? Option A, avulsion. Option B, condemnation. Option C, defeasance. Option D, accretion. The correct answer is option D, accretion. Accretion is gradual addition of land through natural forces. Avulsion is sudden change, condemnation is taking by eminent domain, and defeasance concerns loan satisfaction. Gradual buildup is the key clue. Question 89. A buyer pays 1.5% in discount points on a $328,400 loan. Approximately how much are the points? Option A, $4,926. Option B, $1,779. Option C, $82,100. Option D, $25,656. The correct answer is option A, $4,926. One discount point equals 1% of the loan amount, so the points are calculated by multiplying the loan amount by the point percentage. Monthly interest, down payment, and commission are calculated from different formulas. The point charge is a loan cost calculation, not a sales commission or equity contribution. Question 90. A St. Paul listing agreement omits the real property description. What required element is missing? Option A, the buyer's credit score. Option B, a description of the real property involved. Option C, the lender's underwriting model. Option D, the appraiser's license number. The correct answer is option B, a description of the real property involved. Minnesota listing agreements must describe the real property involved. A buyer's credit score, underwriting model, or appraiser license number is not a required listing agreement element. The contract must identify the property being offered. Question 91. If a broker provides the predatory offender registry notice in a timely manner, what is generally true about offender registry information for Emerson in Red Wing involving a mixed-use property priced at $435,000? Option A, the broker must personally investigate every nearby resident. Option B, the broker must guarantee no offenders live in the city. Option C, the broker has no duty to disclose specific registry information beyond the required notice. Option D, the broker must cancel the purchase agreement automatically. The correct answer is option C. The broker has no duty to disclose specific registry information beyond the required notice. Minnesota disclosure law limits a licensee's duty regarding registry information when the required notice is provided. The broker does not guarantee neighborhood conditions or act as law enforcement. Automatic contract cancellation is not the disclosure rule. Question 92. When Drew, a licensee, intends to buy a client's property in Duluth, what disclosure is required before negotiation or consummation? Option A, the licensee may stay silent if paying full market value. Option B, the disclosure is needed only after the deed is recorded. Option C, only the buyer's lender must be told about the license. Option D, the licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. The correct answer is option D. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 93. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Emerson in Red Wing involving a lake cabin priced at $315,000? Option A. It is a factual misrepresentation about a material property condition. Option B. It is always protected opinion regardless of knowledge. Option C. It is allowed if the buyer gets a loan. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option A. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 94. A parcel borders a lake near Northfield. Rights associated with use of the lakeshore are commonly called what for Hayden in Northfield involving a rental house priced at $436,000? Option A. Riparian rights only. Option B. Literal rights. Option C. Fixture rights. Option D. Novation rights. The correct answer is option B. Literal rights. Literal rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams, fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 95. Why is the Minnesota agency disclosure form given to Parker Davis not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It replaces all purchase agreement requirements. Option C. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option D. It gives the consumer a license to sell property. The correct answer is option C. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 96. Which Minnesota tax is generally associated with recording a mortgage that secures debt on real property for Riley in Bemidji involving a condominium unit priced at $243,000? Option A. Personal income withholding tax. Option B. Sales tax on furniture. Option C. Special assessment appeal fee. Option D. Mortgage registry tax. The correct answer is option D. Mortgage registry tax. Mortgage registry tax is tied to the recording of a mortgage securing debt. Personal income withholding, furniture sales tax, and assessment appeals are different issues. The exam often distinguishes mortgage registry tax from deed tax. Question 97. A sudden flood removes soil from a riverbank in Olmsted County. What term describes the sudden loss for Schuyler in St. Paul involving a duplex priced at $339,000? Option A. Avulsion. Option B. Accretion. Option C. Assemblage. Option D. Plottage. The correct answer is option A. Avulsion. Avulsion is sudden loss or change of land by natural forces. Accretion is gradual buildup, assemblage combines parcels, and plottage is the value increase from assemblage. The word sudden distinguishes avulsion. Question 98. A seller instructs the licensee not to disclose a known structural defect to buyers. Which principal controls for Casey and Woodbury involving a mixed-use property priced at $312,500? Option A. The licensee must obey every instruction from a client. Option B. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Option C. The defect becomes confidential forever. Option D. The buyer's broker alone must discover every defect. The correct answer is option B. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Obedience applies only to lawful instructions. A client cannot require a licensee to hide a material fact that law requires to be disclosed. The duty to disclose known material defects is not shifted entirely to the buyer's broker. Question 99. Two brokerages agree that one will work only north of Winona and the other only south. What antitrust violation may this suggest for Avery in Winona involving a newly built townhouse priced at $363,500? Option A. Redemption. Option B. Assemblage. Option C. A market allocation. Option D. A subrogation. The correct answer is option C. Market allocation. Market allocation occurs when competitors divide customers or territories instead of competing. Redemption, assemblage, and subrogation are unrelated real estate concepts. Geographic division by competing brokerages creates serious antitrust risk. Question 100. A listing agreement states the commission amount but does not explain what event earns it. What required item is missing for Reese in Stillwater involving a condominium unit priced at $307,500? Option A. A promise that the buyer will waive inspection. Option B. A surveyor's certification for every sale. Option C. A court order approving the commission. Option D. A clear statement of the events or conditions that entitle the broker to a commission. The correct answer is option D. A clear statement of the events or conditions that entitle the broker to a commission. Minnesota listing agreements must explain the events or conditions that entitle the broker to compensation. Inspection waivers, surveyor certifications, and court orders are not substitutes for commission earning terms. Clear compensation triggers protect both broker and client.